The Supreme Court just issued an order in a major Second Amendment Preservation Act challenge that's been pending before them. Let me break down exactly what happened in this case and where things go from here. Before we get started, if you want to support the channel, one of the easiest ways is just hitting that subscribe button. It really helps us grow. Today we're covering a significant Second Amendment protection case that was seeking emergency review from the Supreme Court. We've talked about this one before. It centers on a state's Second Amendment Preservation Act, commonly called a SAPA law. You might remember this case because the Supreme Court previously issued an 8-1 order denying an emergency stay that would have protected Missouri's SAPA law. Now the case has returned to the Supreme Court, and we finally have their answer. In their recent order list, the Supreme Court denied emergency review of this Missouri SAPA challenge. Here's what makes this interesting. The Trump administration argued that Missouri's SAPA law is invalid in some of its applications, and that the Supreme Court should deny review. But they also made a promise. If the court denied review and sent the case back to the lower court, the Trump administration would voluntarily release portions of the judgment that the Biden administration had won in the lower court. Missouri responded by arguing that this concession from the Trump Department of Justice is exactly why the Supreme Court should take the case. The matter went to conference on September 29th, and then we got the Supreme Court's order. The court decided to deny emergency review, meaning this heads back to the lower court. But there are still developments that could work in favor of Missouri's SAPA law. Let me give you some background if you're not familiar with this case. This lawsuit is about a 2021 Second Amendment Preservation Act that Missouri passed. The law established the state's interpretation of the Second Amendment and placed restrictions on how much support and funding the state would give to federal agencies trying to enforce federal laws that Missouri believes violate the Second Amendment. Specifically, the law prohibits Missouri officers, agents, and government officials from assisting federal agents who are attempting to enforce what the state considers unconstitutional laws. The law also created a civil remedy allowing any Missouri resident to sue a Missouri official if that official helps enforce federal laws that the state believes violate the Second Amendment. Basically, the law was designed to put enforcement power in the hands of Missouri residents and citizens rather than state officers or agents. In the Missouri case, the district court reviewed the law and ruled in favor of the Biden administration at the time, striking down the Missouri Preservation Act completely. A universal injunction was placed on the entire law. Missouri then appealed to the Eighth Circuit and requested a temporary stay on that universal injunction, which eventually led them to seek emergency intervention from the Supreme Court. But when the Supreme Court reviewed it, they issued that 8-1 order denying the emergency relief. Only Justice Thomas supported stepping in and granting the emergency stay. After that 8-1 order denying emergency relief, the case went back to the Eighth Circuit. They heard oral arguments and issued their ruling. The Eighth Circuit ruled in favor of the federal government, striking down the SAPA law entirely once again. Missouri then filed their petition asking the Supreme Court to step in and review the issue. One of Missouri's main arguments in their petition was that the Eighth Circuit essentially acknowledged the structure and operation of the law was valid, but struck it down anyway because they disagreed with its underlying Second Amendment purpose. Missouri argued that the Eighth Circuit ignored clear precedent and wrongly concluded that state officials could be sued because the court believed the state played a role in enforcement simply by complying with state law. In other words, the Eighth Circuit treated compliance and non-action as if it were actual enforcement and action. The Biden administration originally opposed this case and law, but now the Trump administration controls the case. Initially, the Trump Department of Justice delayed their response for several months. When they finally responded, the Trump administration continued arguing that the SAPA law is invalid and that the lower court ruled correctly. However, they also told the Supreme Court that if the court denied review and the case returned to the district court, the Trump Department of Justice would dismiss portions of the universal injunction they won. In their response, They stated that after reevaluating the case, the United States has concerns about whether the judgment extends too far and blocks applications of the act that actually constitute mere non-enforcement of federal law, which is protected under the anti-commandeering doctrine. They noted these concerns are made worse by the uncertainty in this pre-enforcement situation about how certain provisions of the act will be applied, and whether the provisions the Eighth Circuit focused on are truly inseparable from the rest of the act. Given these concerns, the United States decided it would agree to narrowing the scope of the judgment. So, after stalling for a few months, the Trump Department of Justice responded by maintaining that the SAPA law is invalid and that the Supreme Court should deny review. But at the same time, they promised that if review was denied and the case went back to the district court, they would release portions of that universal injunction. The Supreme Court recently issued an order on their order list denying emergency review of the SAPA case. Despite this denial, I want to be clear that this case isn't finished. It's going to keep moving forward. As the United States stated in their request for denial, once the case returns to the district court, they'll be releasing some of the preliminary injunction that was issued in their favor against Missouri's SAPA law. This means there may be ways the SAPA law can be implemented. Since this was a pre-enforcement challenge, perhaps they're going to allow some provisions to go into effect. Maybe they want to see how it plays out, determine if some provisions are severable from others, and observe how the law operates in practice. At least that seems to be what the Department of Justice was hinting at when they said they would release some of the universal block issued by the lower court. Even though the Supreme Court denied emergency review, the case will continue at the lower court level in the Western District of Missouri. The Supreme Court will send it back to the Western District, and we'll see how that district court responds. The Trump Department of Justice claims they'll be releasing portions of the judgment the Biden administration won. We'll have to see how that unfolds in the lower court, and whether the district court will even allow it to happen. So the Supreme Court once again denied emergency review and declined to get involved with this SAPA issue. But there's still reason for optimism and positive movement toward keeping some of Missouri's SAPA law in place and potentially seeing portions of it implemented. Remember, this was largely pre-enforcement. The law wasn't allowed to fully take effect. It appears there's some willingness from the Trump Department of Justice to say, okay, let's allow some of this to be implemented and see how it operates. Are the problematic parts severable? Are the issues the lower court identified actually real problems? We'll see how this develops. That's what happened in this case. As I mentioned, it's heading back to the lower court. The Trump Department of Justice says they'll release portions of that judgment, and we'll see what impact that has on Missouri's SAPA law. As we get more information and developments, I'll keep you updated. If you found this video helpful and want to support the channel, one of the best ways is to subscribe. As always, thank you so much for all your support.